So you have a robbery case because you wanted beer.
I just lost my dad and I was coping the wrong way with alcohol and drugs.
All right, so here's the thing. Everybody, I will tell you, every human being who is sitting here in this courtroom today has lost somebody. Can you imagine what this world will be if everybody goes out to do a beer run? Now, what type of beer was it?
I believe it was Miller Lite.
All right. No, do you want the deferred where if you were revoked, you're potentially looking at 20 years? Or do you want the conviction where the most anyone could sentence you to would be 10 years?
The gavel strikes.
Defense?
Richard Garcia for the defense. Ready, Your Honor?
And are you Mr. Rendon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, we did.
Court will find that the state is in compliance with discovery. Mr. Rendon, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Rendon, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
You're charged with robbery. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, is there an application for deferred adjudication or no?
We just put one in, Judge.
All right. And is the state silent on that application or no?
No.
Judge, we'd offered probation. If you want to apply for deferred, that's fine, but we'll be silent on that.
Silent on the deferred, but they're
Recommending
recommending probation.
I can
All
fix it.
Thank you. All right, did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor. And when you have a minute, I would like to put some information on the record.
Is it related to competency?
It's related not to competency because I find him competent. It's related to the prior offers that were offered to him.
Sure.
And
All right.
if can I do it now? Or you tell me when.
All right, thank you. All right, Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The state is silent on your application for deferred adjudication. The state recommends community supervision, and there's to be restitution, if any, to the complainant. Did you understand that to be the plea?
Your Honor.
Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor, there haven't.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant or Circle K at 1002 Castroville, San Antonio, Texas, 78237. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
City exhibit number one with all this attached.
No objections, Your Honor.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
So, yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And counsel, if you would like, you can put what you wanted to put. The court has reviewed states exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Do you wish to proceed to sentencing?
Yes, we do, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor, well, the incident was at a Circle K and it was a beer run.
All right, how old are you?
45.
So you have a robbery case because you wanted beer.
I was wrong. I just want to be clean and sober and not break the law. That's all I want to do, Your Honor.
No. So you picked up a robbery case because you wanted beer.
And I just lost my dad and I was coping the wrong way with alcohol and drugs.
All right, so here's the thing. Everybody, I will tell you, every human being who is sitting here in this courtroom today has lost somebody. Can you imagine what this world will be if everybody goes out to do a beer run? Now, what type of beer was it?
I believe it was Miller Lite.
All right. State, what is Mr. Rendon's criminal history? Do you have criminal history?
Yes.
And what is your criminal history? Yes. Have you been to prison before?
Yes.
What have you been to prison for?
Possession of drugs.
All right, anything else?
No.
Do you have any violent history?
No.
Any assaults, any other robberies, any other thefts?
No.
So it's just drugs? So- State?
And I do have 1 DWI from back then.
Okay. Is there
That's
anything?
correct, Judge. I mean, he has driving while intoxicated, possession, less than 1 gram, and then also possession of marijuana. He'd been arrested, for assault back in 2018, physical trespass, driving while license invalid, and other drug charges, but the only convictions are the DWI, less than 1 gram, and then also the possession case, Your Honor.
All right, thank you.
That's Your Honor.
All right, so I'm going to give you a choice. These are your choices. I could grant your application for deferred adjudication. If for any reason you end up being revoked from that deferred adjudication, you're looking at potentially 20 years in the prison. If I were to deny your application for deferred adjudication, and if for some reason you were revoked, the most you would be looking at is 10 years. You know yourself better than I do, better than your attorney does or the state does. So if you want the deferred adjudication, I will give you the deferred adjudication. But if you were to get revoked, you're looking at 20 years in the prison. So which do you prefer?
Do the probation and I'll behave myself.
No, do you want the deferred where if you were revoked, you're potentially looking at 20 years? Or do you want the conviction where the most anyone could sentence you to would be 10 years?
So remember, we went over the deferred right now, and deferred, if you've completed satisfactorily, you won't have a conviction on your record. But if you want to go the deferred route and you mess it up, you could go up to 20 years. However, if you don't want to take that risk and you want the conviction today, the most you could do is 10 years.
The second one.
The second, so you want a conviction on your record.
Well, I mean, if it's gonna be, I mean, I don't wanna look.
You will, like the judge said, you know yourself better than we do.
I'd rather have the deferred and so that I don't have that on my record.
Well, here's the thing. It's always going to be on your record. It's just not going to be a conviction. So if somebody's looking at your record, it's going to show that you were placed on deferred adjudication for robbery. Even if you successfully complete it, it's still going to show robbery, dismiss, deferred adjudication.
And then just the conviction. The conviction.
Okay. The court will find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. So when you were using, what type of drugs were you using?
It was meth.
All right. We're going to do a TAP evaluation and felony drug court evaluation in custody. That will be completed before the week is out.
Okay.
Follow recommendations of TAP if he's not accepted into felony drug court. There's to be restitution, if any, to the complainant. Counsel, if for any reason you believe the restitution is not what it should be, you can ask for a restitution hearing and we'll have a hearing.
Thank you, Judge.
And there's to be no contact with the complainant. And there's to be no contact with Circle K. $200 of community service restitution. How far did you go in school?
I graduated from high school.
All right, what are you planning on doing with the rest of your life?
I'm gonna try to go back to Spice of Life Catering and work for them.
All right, awesome. Spice of Life Catering, they do have great food. I've been there as well, where we've had events. Their food is awesome.
Mike Bomberg is, I know, Mike Mr. Bomberg.
All right, so there's going to be 200 hours of community service restitution. 200 hours will be waived if he obtains some sort of trade school certificate or goes back to school. So if you want to do a culinary degree thing, if you do that, the 200 hours will be waived. Who's your support system here in San Antonio?
Where
I mean, who do you have that you can depend on, that you can call up? If
actually my ex-wife has been there for me.
Okay, do you have any family here?
My dad was my closest, but like I said, I just lost him. And I'm just going through the mourning part. It's only been a year.
All right, that can be, I know that can be very hard. I've been there. All right, and then there's going to be 90 sober meetings in 90 days. Do you have any children?
Yes.
What are their ages?
My oldest is 28. And my 3 sons are 24, 22, and 19.
Do you have any grandchildren?
Yes.
And what are their ages?
They were 2 of them were just born. Spencer is my oldest grandson, and Damon was just born but going on a year ago, so.
Okay. All right, so there'll be no unsupervised contact with minors. Once you are clean and sober, then the court will consider allowing you to have contact, okay? And contact that's unsupervised. All right, probation, is there anything else he needs? Thank you. Field visits 1 time per month until further notice. Is there anything else you need from the court to be successful?
So about when would I be able to be released to the free world?
Probably next week,
Okay.
but if they say that you need inpatient treatment, you're gonna go into inpatient treatment.
Oh, okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, yes. Your
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, to be successful on probation, communication is key. Obviously, probation wants you to have, the state wants you to have probation. I think that maybe you can be successful at it. Otherwise, I wouldn't have agreed to it, okay? So you need to communicate with your probation officer. If you feel you're going to use, let probation know. I normally don't revoke people because they call probation and say, I'm going to use. What I try to do is, what can we do to help you not use? All right. If you feel they're not addressing any issues you have, you can always come back to court. All right. Good luck to you.
Thank you, Your Honor.
Thank you, Judge.
The hearing begins with formal plea confirmations as Judge Stephanie Boyd verifies that the defendant understands his robbery charge, the possible punishment range of up to 20 years in prison, and the rights he is giving up by entering a guilty plea. The defendant confirms that he reviewed all documents with counsel and acknowledges the seriousness of the charge. The state remains silent on the application, while the defense indicates a recommendation for probation. After the guilty plea is entered, Judge Stephanie Boyd reviews the evidence and determines there is sufficient basis to find the defendant guilty. The court temporarily defers the finding of guilt to consider sentencing options. When asked to explain the offense, the defendant states that the robbery was the result of a beer run, immediately triggering a firm reaction from the judge. Judge Stephanie Boyd emphasizes the defendant's age and challenges the logic behind committing a robbery over alcohol. As the hearing continues, the defendant admits to a criminal history that includes prior prison time for drug possession and a DWI. This background becomes central to the judge's next move. Judge Stephanie Boyd presents a high-stakes choice: accept deferred adjudication with the risk of facing up to 20 years if probation is later revoked, or accept a conviction with a capped maximum exposure of 10 years. The courtroom tension rises as the defendant hesitates, initially expressing a desire for probation without fully understanding the consequences. After clarification from the court, the defendant ultimately chooses the conviction option. Judge Stephanie Boyd immediately finds him guilty and imposes a 10-year prison sentence, suspended and probated for 8 years. The judge then outlines strict probation conditions, including drug testing, employment requirements, no contact with the victim, restrictions involving minors, substance abuse treatment evaluations, community service, and mandatory sober meetings. Judge Stephanie Boyd closes the hearing by emphasizing the importance of communication with probation officers and accountability during supervision. While offering encouragement for sobriety and rehabilitation, the judge makes it clear that compliance is mandatory. The defendant thanks the court, and the case concludes with a powerful reminder of how courtroom decisions carry lasting consequences.